Good afternoon. We'd like to welcome you to our next Health Law Basics webinar. Today we are talking about gifts to referral sources, including patients and other providers and others. It's officially the holiday season, so we're all in the gift-giving mood. So we thought we'd touch base on some of the laws that affect that gift-giving process. So this is what we're going to talk about today. We're going to talk about some of the relevant laws, give you a quick overview, then we're going to apply those laws to some common situations, including gifts to or from referral sources, specifically gifts to physicians, gifts to or from patients, gifts from vendors. Now when we're doing this, this program today is focusing primarily on gifts that you would give kind of around the holiday season. We're not going to go through all of the situations or all of the exceptions that might apply if you're going to provide discounted items or services to patients, that type of stuff. We're kind of focusing on the gift type of things. If you've got questions throughout this process or throughout this program, you can use that chat feature and send them to me, or you can shoot me a quick email. We probably won't take those questions during the program, but I'll respond offline afterwards. As far as written materials, hopefully you've got the link for those. If not, send me a quick email. I apologize. It's been a very busy week, and so I didn't get those out to Susan until later. But if you want the written materials, you haven't received them yet, let me know. The written materials include a copy of the PowerPoint slides, a client alert that I sent out a year or two ago dealing with gifts to referral sources and patients, a copy of the OIG Special Advisory Bulletin on offering gifts and other inducements to beneficiaries, and a sample compliance plan standards of conduct, which includes, among other things, some information concerning gift giving. It's designed to be kind of a standards of conduct that you could incorporate into your compliance plan. So, with that said, let's talk about gift giving. What is the big deal? Is this just yet another situation where the government is taking the fun out of Christmas along with practicing law? Well, the government is concerned that offering gifts or other kickbacks to referral sources could result in a whole host of problems. It could result in overutilization because physicians, other providers may order services in order to get the inducement rather than the client's best interest. In addition, it may be a situation where those providers who are providing these gifts may feel the need that they have to, in order to offset costs, increase the charges or increase the services that are being provided in order to offset those costs. All of that could result in increased government program costs. It could adversely affect the corrupt the medical decision making. So the provider is no longer making decisions based on the best interest of the patient, but instead based on their own best interest or their own self-interest. Could result in patient steering and unfair competition if those providers who have more assets can offer bigger gifts and therefore put smaller entities at a competitive disadvantage. So what did the government do about that? After considering it, the government response is the Federal Anti-Kickback Statute, the Ethics in Patient Self-Referrals Act, or STARK, the Civil Monetary Penalties Law. Those are the federal statutes that we deal with most of the time on these issues, but there could also be state laws, including anti-kickback statutes, fee-splitting statutes, rebate statutes. There could be many Stark laws or other situations that might apply. So let's talk first about the anti-kickback statute. The anti-kickback statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by government healthcare programs unless the arrangement is structured to fit within the regulatory safe harbor. A couple of points about that. The anti-kickback statute is incredibly broad. Note that it applies to anybody. Not just physicians, not just healthcare providers, but anybody who knowingly and willfully offers, pays, solicits, or receives remuneration to induce those referrals for program benefits. Note also that it applies to both the giver and the receiver. It applies to those who offer, pay, those who solicit, or receive. So even if you are the recipient of this gift, you could also be liable for an anti-kickback violation. Now, it only applies to those who knowingly and willfully offer, pay, solicit, or receive that stuff. But when you talk about that knowingly and willfully, that means that it's an intent-based test. You have to intend to make that offer in order to induce the referrals. But the government has adopted with the anti-kickback statute what's called the one-purpose test. That means that the anti-kickback statute applies if one purpose of the remuneration is to induce referrals, even if there's 99 other legitimate purposes. And ignorance of the law is no excuse. It used to be in the Ninth Circuit, where I practiced primarily, there was the way the courts had interpreted it, that if you did not know that you were violating the anti-kickback statute, that was a defense. Well, the Affordable Care Act took that out. Now, ignorance of the law is no excuse. What happens if you violate the anti-kickback statute? Well, a bunch of bad stuff. The anti-kickback statute is actually a criminal statute. It's a felony. That means you can go to jail, 5 years, up to 5 years in prison, a $25,000 criminal fine. You can also get hit up with a $50,000 administrative penalty. You can have to repay treble damages, and it's automatic exclusion from Medicare and Medicaid. Now, if any of you think that you may have an anti-kickback problem and you want to go through the OIG self-disclosure protocol, the OIG has said that they will require a minimum settlement of $50,000 if it's an anti-kickback situation. In addition, in the wake of the Affordable Care Act, an anti-kickback violation is also an automatic violation of the False Claims Act. That means that you can also get hit up with the False Claims Act penalties of $5,500 to $11,000 per claim. And because the False Claims Act is a civil statute, that means the government can go after you with a lower standard of proof. They just have to prove that you violated by a preponderance of the evidence instead of beyond a reasonable doubt as they would under the criminal statute. In addition, you have to be worried about third parties filing a whistleblower suit under the False Claims Act. The False Claims Act allows them to assert these key TAM lawsuits that would allow that key TAM relator to recover a percentage of any recovery against you. So you may be wondering, well, how would the government ever catch me? Well, they might catch you because one of your employees may decide to turn you in order to get the key TAM bounty that may be on your head. All right. The next statute we got to be concerned about is STARK, or the Ethics and Patient Referrals Act. STARK says that if a physician or their family member has a financial relationship with an entity, and by the way, giving a gift to another entity creates a financial relationship. So if a physician or their family member has received a gift or gives a gift with another entity, that physician may not refer patients to that other entity for certain designated health services, and that other entity may not bill Medicare for such designated health services unless you've structured the arrangement to fit within a regulatory exception or safe harbor. So the bottom line here is if you are given a gift or receiving a gift from this other physician, and that physician makes referrals to you for certain designated health services, then you can't bill Medicare for those services. And if you have billed Medicare improperly, what do you need to do? You're going to have to repay that amount that you improperly billed and received. If you fail to repay within 60 days, then you can get hit up with additional civil penalties of $15,000 per claim submitted. Now, STARK violations may also constitute anti-kickback statute violations, so you may have to deal with the anti-kickback statute too. In addition, STARK violations could also trigger False Claims Act violations. Therefore, you could be hit up with additional penalties there. Now remember, STARK, unlike the anti-kickback statute, STARK only applies to physicians, financial relationships with physicians or the physician's family members. The anti-kickback statute applies to anybody, but STARK only applies to referrals by a physician to entities with which the physician or their family member has a financial interest. In addition, the anti-kickback statute applies to referrals for any item or service that's covered by federal health care programs. In contrast, the STARK law only applies to referrals for certain designated health services that are payable in whole or in part by Medicare, those items that are listed up there on the screen. So not all referrals from these referral sources are going to trigger STARK law violations. It's only those referrals for designated health services. All right, the next one we got to worry about is the Civil Monetary Penalties Law. The Civil Monetary Penalties Law actually covers a whole bunch of stuff, including it prohibits giving kickbacks and things like that. But the one that we're most concerned about today is the Civil Monetary Penalties Law prohibits offering inducements to program beneficiaries if you know or should know that inducement, that remuneration, is likely to influence the beneficiary to order or receive items or services payable by federal or state programs from a particular provider. So if you are offering gifts to a program beneficiary in order to induce that program beneficiary to come to you for federal program business, that is a potential violation of the Civil Monetary Penalties Law. What are the penalties? Well, the penalties under the Civil Monetary Penalties Law vary depending upon the type of conduct, but they generally range from $2,000 to $50,000 in fines per violation. For purposes of this violation dealing with gifts, I believe the penalty is $10,000 per violation. You could also get hit up with treble damages, denial of payment for claims that were submitted, repayments of amounts improperly paid. You could be excluded from government programs. And a violation of the Civil Monetary Penalties Law could also result in a violation of the False Claims Act, the Anti-Kickback Statute, and Stark. All of those can lead to the False Claims Act, which says that you can't knowingly submit a false claim for payment to the federal government, and if you have, you've got to report and repay within 60 days. If you don't, a whole parade of horribles can rain down upon your head. So if you have provided services pursuant to an improper referral, and you've been paid for that, that could potentially result in a False Claims Act situation. Now, those are the federal statutes. There are other state laws that may apply. Now, these are going to vary depending on the particular state, so you have to know your own particular state law. Most states have their own version of the anti-kickback statute. Some of those states only apply that to government program business, so it's only kickbacks in order to get Medicare money. Some of them also are broader than that, and they will apply to any types of kickbacks. Some states have their own mini Stark laws, which are versions of the federal law. Some have disclosure laws, so that if there's a financial relationship created, then you have to disclose that to your patients at the time you make that referral. Almost all states have fee-splitting statutes that apply to physicians that prohibit physicians from splitting their fees with, for example, referral sources. Some states have anti-rebate, anti-capper, anti-runner statutes. The bottom line is you need to know your state laws when it comes to applying these things. All right, that's a quick background of the laws we're going to deal with. Let's apply them to some specific situations. First, gift to referral sources. The key here is to remember that, according to the OIG, in some industries, it is acceptable to reward those who refer business to you. However, in the federal healthcare programs, paying for referrals is a crime. That's the anti-kickback statute. That may include paying anything to any types of referral sources. Those referral sources could be other physicians, other providers, maybe staff at the other providers' offices. You send over a nice gift basket, something like that. Could be hospitals, other physician groups, anybody else. Could be payers, could be vendors, patients, anybody that you are paying or offering inducements in order to send you federal program business. Those inducements can take any form. It could be cash, but it doesn't have to be cash. It could be gift cards, gift baskets, it could be food, sending over, a meal, wine or alcohol, providing them parties, tickets, events, services, any other form of remuneration or item of value. If you're giving something a freebie or free or discounted item or services, you got to be worried about the anti-kickback statute, and that is going to turn on your intent. So the anti-kickback statute is going to apply to these gifts between referral sources if there's an offer to give, solicit, or receive remuneration. And remember, that applies both to the giver and the receiver. You've heard it said that it's more blessed to give than receive. I guess for the purpose of the anti-kickback statute, it's the same. You're cursed whether you are the giver or the receiver. In addition, one purpose has to be to induce referrals. Now, if that one purpose test, the problem with that is it's a little bit difficult to disprove. If you send over a big gift basket to a referring physician, how do you establish that, no, I didn't do that because he was making referrals to me? How do you preclude the possibility that the government's going to say one purpose was to induce referrals? The third element that they have to prove is that it's for items or services covered by a government health care program. Again, the anti-kickback statute only applies to kickbacks or inducements for items or services covered by government programs. it probably does not apply to gifts that you send to referral sources if that referral source is simply a referral for private pay business. However, the government has warned that even those gifts or other inducements to private pay referral sources could also implicate the federal anti-kickback statute if that referral source is also sending you over government program business. Because the government says, let's get real. If you're sending them a gift for the referrals for the non-government business, they're also going to send you their government business, and therefore that gift you're providing is really inducing the referrals for government business also. So the fact that you try to carve out non-government business from this program does not necessarily mean you're going to be safe. Now, the anti-kickback statute does not have a de minimis exception. There is nothing expressed in the anti-kickback statute that says, hey, if it's only a pen or if it's only worth X dollars, you're safe. However, the OIG has said that they've got better things to do than to go after somebody just maybe for an inexpensive gift. They've issued for small group physician practices. The government said that the AKS may apply for offering each gift group more than value to or from those who may benefit from a physician's practices referral for federal health care program business. So, according to this, it suggests that if all you're doing is giving a gift of nominal value, you may be okay. The problem, of course, is what is nominal value? We don't have a lot of guidance on that. We think it may mean the same test that's applied under the Civil Monetary Penalties Law, which I will come to in a minute, but there are no guarantees. So the bottom line here is when you're dealing with gifts to referral sources, the general rule is this. If it's a government program referral source, you got to be concerned about the federal anti-kickback statute, especially if the gift is of more than nominal value, whatever that means. On the other hand, if this referral source only sends private pay business, well, that's less risky. You're probably going to be okay if there are no federal programs involved. But you still have to be aware of state laws because state laws may be more broad than the federal anti-kickback statute. All right, that's the general rule for dealing with gifts to referral sources. Let's talk more specifically about physicians, because when we're talking about physicians, you got to be concerned about Stark. So the anti-kickback statute's very broad, applies to anybody. When you're dealing with physicians, you got to not only be concerned about the anti-kickback statute, but about Stark also. Remember, Stark applies if the gift is to the physician or the physician's family member, and that physician refers certain designated health services payable by Medicare, unless you structure the transaction to fit within a regulatory safe harbor. Now note here that unlike the anti-kickback statute, there is no intent requirement under the Stark law. It doesn't matter whether you just gave a pen or something of nominal value, or if there was just a technical violation. It doesn't matter whether you intended to really induce referrals. For purposes of the Stark law, it's a strict liability statute. You either comply or you don't comply. Your intent is irrelevant. Note also that the Stark law only applies to referrals for the certain designated health services payable by Medicare. It does not apply to referrals for private pay business. So if that physician to whom you are giving this gift basket only refers non-Medicare business to you, then you don't have to worry about Stark law. You still may need to worry about the anti-kickback statute, but you don't have to worry about Stark. Now, even if that physician is making referrals to you for designated health services, there are a couple of potentially relevant safe harbors. As long as you structure that arrangement in order to fit within these safe harbors, then that's fine. That gift will not trigger a Stark law violation. But they're very limited. If you want to give a gift to one of your employees who is a physician, the Stark bona fide employment safe harbor applies. If that physician is a bona fide employee, the employment is for identifiable services, and the amount of the remuneration under the employment is consistent with fair market value for the services. So your gift that physician is not going to push them over fair market value, so I guess you got to be concerned about giving them a Mercedes, but not going to have too much of a problem giving them a gift basket. However, that gift also cannot be determined in a manner that takes into account directly or indirectly the volume or value of any referrals by the referring physician. So you don't give them the gift because they were a good referral source or generated a whole bunch of business for the employer. And the remuneration is provided under an agreement that would be commercially reasonable even if no referrals were made to the employer. So those are the situations. That's the standard that would apply if you want to give gifts to your physician employees. There's also a broader safe harbor that applies to non-monetary compensation. This is a situation where maybe you want to give a gift to another physician, not your employee. Then you can rely on this exception if you satisfy certain criteria. First, it only applies to items or services that are not cash or cash equivalents, not gift cards, not a Visa gift card, nothing like that. It's non-cash or cash equivalents. Also, the aggregate value of that gift has to be less than or all of the gifts that you give in that year have to be less than $385. Now that started out as $300, but every year there's an adjustment. So for 2014, the current standard is $385 per calendar year. So looking back, you could give gifts to referring physicians so long as those gifts in the aggregate did not total more than $385 in value. Now, gifts cannot be determined in a manner that takes into account the volume or value of referrals or other business generated by the referring physician, meaning that you're not giving them that gift because they made referrals. That gift cannot be solicited by the physician or physician's practice, so you guys who are physicians or physician offices, you can't think, okay, well, gee whiz, we want that $385, so we're going to call up the local hospital and have them send it to us. That doesn't work. That would not fit within this safe harbor. And finally, that gift still cannot violate the anti-kickback statute or other state or federal law, meaning that not one purpose of that gift can be to induce referrals. Now, in addition to the non-monetary gifts valued at no more than $385, in addition to that exception, this Stark Law exception would also allow hospitals or other entities that have a formal medical staff to throw one big party or one staff appreciation event per year for the entire medical staff. That event does not count against that $385 aggregate, but if you're going to give any gifts or gratuities in connection with that event, you do have to count those against that $385 limit. Well, what happens if you're thinking back and saying, oh, good heavens, we've provided more than $385 worth of gift to our physicians or our associated physicians. What do we do about that? Well, the government has come up with a way to allow you to essentially repent. They've said that where an entity has inadvertently provided non-monetary compensation in excess of that $385 limit, such compensation is going to be okay so long as the value of the excess is not more than 50% of the limit. So I guess your total was not, what, about $500, $500 and some odd dollars. And the physician returns the excess by the earlier of. So the physician's got to pay back the excess by the earlier of the end of the calendar year in which the compensation was received, or within 180 days after the compensation was received. Now, that's the earlier of those two. So I guess if you gave this gift on New Year's Eve, you're kind of screwed because the time period would run before you have a chance to repay it. But nevertheless, that's the way the government wrote this thing. In addition, you can only use that exception, that repentance process, only once every 3 years for the same physician. Now, there is a separate Stark exception that allows hospitals or other entities with a bona fide medical staff to provide certain medical staff incidental benefits to the medical staff members. This doesn't arise very often in the gift context, but for sake of completeness, I thought I'd throw it in here. It allows those hospitals to give items or services that are not cash or cash equivalents. Those items or services have to be used on the hospital's campus. They have to be offered to all members of the medical staff practicing in the same specialty without regard to referrals or business generated between the parties. They have to be provided only during the periods when the medical staff members are making rounds or engaged in other services that benefit the hospital or patients. They have to be reasonably related to the provision of services at the hospital, and the value for each of those has to be less than $32 per year. That's adjusted annually. So the classic example is you could offer to your physicians that they get free meals in the cafeteria or discounted meals in the cafeteria while they're on shift. Also, that gift that you're offering cannot violate the anti-kickback statute, so you can't do that in order to induce their further referrals. There's another exception that would allow physicians to make bona fide charitable donations to a tax-exempt organization. So maybe it's a situation where you want to give a gift, but you can't, you can't just give a dollar amount or non-monetary compensation amount, but you can go ahead and make a charitable donation on behalf of the other entity or in your own behalf. That donation cannot be solicited or offered in any manner that takes into account the volume or value of referrals or other business generated between the physician and the entity. And the donation arrangement cannot violate the anti-kickback statute or similar state or federal law, so you can't do it with the intent to induce referrals. So for those of you who are Seinfeld fans, it looks like George Costanza had it right after all, that you could offer to make a charitable donation to another nonprofit entity in lieu of giving a gift directly to a referral source. All right, that is a quick summary of the laws dealing with referrals to physicians and other referral sources. But what about gifts to patients? Well, patients can refer themselves to you, and therefore they could be a referral source. So you got to be concerned about the anti-kickback statute. You got to be concerned if you're giving patients gifts in order to induce referrals for items or services covered by government health care programs. The rules we talked about earlier apply there. In addition, if that patient is a physician or a member of a physician's family and that physician refers designated health services, you got to be concerned about Stark. But most importantly, you got to be concerned about the civil monetary penalties law, which, as we mentioned, applies if you know or should know that the remuneration is likely to influence the beneficiary to order or receive items or services payable by federal or state programs from a particular provider. So that generally prohibits gifts to patients if it's going to induce them to come to you for federal program business. But the OIG has said, hey, we're going to allow you to make those gifts to Medicare or Medicaid beneficiaries so long as they are inexpensive. And the government has defined inexpensive as to mean that each of those gifts is worth no more than $10 individually, and the aggregate value of the gifts that you give in a year is no more than $50 per patient. And those gifts have to be non-cash or cash equivalent. So you can't necessarily give a gift card or that type of stuff, but you could give other inexpensive gifts that are not cash or cash equivalents. So that's the general rule for gifts to patients. Now, the anti-kickback statute, remember it said that you could probably give gifts of nominal value. I think that it's probably relatively safe to assume that the OIG would apply this same type of limit to the anti-kickback statute, that it would probably allow you to give or receive gifts that are worth no more than $10 individually and no more than $50 in the aggregate annually per patient, but we don't have any specific guidance on that, so be careful. Real quickly, what about gifts from patients? You're a physician and you received gifts from patients. Can you receive those? Well, really no statutes unless they're done to induce referrals by you to somebody else, but there is an AMA ethics opinion which basically says that there's no definitive rules to determine when a physician should or should not accept a gift. Basically, you just need to be wise in what you're doing. You should consider things like the gift's relative value. You need to make sure that it's not going to affect your clinical judgment. It may indicate that the patient is unwise in making a very large gift, and maybe that's something that you need to address with them. All of those things are considerations that you should run through your mind when you're receiving gifts from patients. All right, what about gifts from vendors? So you've got that pharmaceutical company. Remember those happy days when those pharmaceutical companies used to offer big trips or free equipment or supplies, meals, CME, sham service arrangements, all those types of things that were very lucrative for physicians for a time being. What happened to those? Those all went away. Why? Because the government started enforcing the anti-kickback statute. The anti-kickback statute applies if one purpose of that gift was to induce referrals for items or services payable by government programs. Again, even in the context of vendors, the government has suggested the nominal gifts likely would not be challenged, but we don't have a whole lot of guidance concerning the nominal gifts. Probably the government's not going to come after that vendor or you if they're dropping off a pen or a pad of paper or something like that, but if it's something more substantial, there is a risk for an anti-kickback violation. In addition, if you are a physician and you may refer or order items or services that are designated health services from that giver of the gift, you got to be concerned about Stark. A word about free drug samples. The government has said that many drug and biologic companies provide physicians with free samples that physicians may give to patients free of charge. That's okay, as long as you're passing along to the patient. However, it is legal to give these samples to your patients for free, but it is illegal to sell those samples and collect the money for yourself. Now, the rules governing gifts from vendors are generally covered then by those federal anti-kickback statute, and if you're a physician, then by Stark. In addition to that, you've also got to be concerned about the AMA guidelines if you want to be ethical. The AMA has issued an ethical opinion concerning gifts from vendors. Also, there are other ethics code provisions that apply to pharmaceutical manufacturers and medical device manufacturers. The AMA code says that to preserve the trust that is fundamental to the patient-physician relationship and public confidence in the profession, physicians should decline cash gifts in any amount from an entity that has a direct interest in the physician's treatment recommendations, decline any gifts for which reciprocity is expected or implied, or accept an in-kind gift for the physician's practice only when the gift will directly benefit patients, including patient education, and is of minimal value. So, to the extent you want to be ethical, that's the guidance that has come out from the AMA. In the wake of the Affordable Care Act, we also have the Physician Payment Sunshine Act, which now requires medical device and pharmaceutical companies to report annually to CMS any payments or other transfers of value that they make to physicians or teaching hospitals. So if that pharmaceutical company is providing these items of value to you, they've got to report that in the report that goes to CMS, and then that is posted on the website. That excludes payments of less than $10 individually or $100 in the aggregate annually, and certain educational materials and in-kind items for charity care. When that manufacturer submits the report, they are going to include the name and the address of the physician who received it, the amount and date of the payment, the form of the payment, such as cash or stocks, the nature of the payment, such as consulting fees, gifts, or entertainment expenses. And that is available for public to view, effective, I believe that went live in September. For those of you who haven't seen it yet, you can go to this website. This is where anybody can go in and access that information. You can do a search of the doctor's name and find out if and to what extent they've been receiving gifts from pharmaceutical manufacturers or medical device manufacturers. In addition to perhaps creating some embarrassment from colleagues or others or raising questions about the motivations, there's also a chance that if the government sees those reports, when they get those reports and see significant gifts going to a particular physician, that may increase the likelihood of government investigation. So you got to be a little bit concerned about accepting those gifts from the vendors. All right, that is a very quick summary of the rules governing gifts. Let's talk about, just to summarize, as you noted, most of those rules apply if you are going to accept government money, if you're going to participate in government programs. Remember this, that any time you accept government money or participate in the government programs, there are always going to be strings attached. In this case, the strings are the federal anti-kickback statute, the federal Stark law, and the civil monetary penalties law. If you're not dealing with government programs or referrals for government programs, gift giving is not as risky, but there's no guarantees. On the other hand, if you are dealing with referral sources or patients involved in government programs, you got to be concerned about those statutes. So you got to ask yourself, when it comes to time to give a gift this holiday season, before giving or receiving that gift, more than a nominal gift, ask yourself, is the recipient a referral source for items or services covered by government programs? Are they a referring provider? Are you giving the gift to patients who are government beneficiaries? If yes, you got to be concerned about those statutes. Ask yourself, why are you giving the gift? Is it to thank them for past referrals or business? Or to encourage future referrals or business? If it is, you got to be concerned about the anti-kickback statute, because it sounds to me like one purpose of that gift is to induce referrals. And why are you giving the gift to this person and not others? Is it because that recipient is a good source of business and you hope to receive future business as a result of the gift? If so, then the red flags ought to be waving. We've talked about the federal laws, but remember that there's also state laws, and those state laws may be broader than the federal laws. They may apply to non-government program business. For example, here in Idaho, we have a state law anti-kickback statute that's actually broader and applies to even private pay business. So make sure you're aware of the scope of your state laws. Again, those common state laws could include anti-kickback statutes, mini-Stark statutes, fee-splitting statutes, rebate statutes, statutes that require disclosure of relationships, or others. In addition, even if there aren't express statutes, beware of the conflicts of interest that may be created by the gifts. Some of your grant requirements may require you either to disclose or to not be engaged in this course of the grant with any entity from whom you've received or have a financial relationship, and so you need to make sure you're going to comply with those grant requirements. And even if the law doesn't prohibit this, you should be concerned about ethical concerns. Specific red flag situations: gifts to or from resources who refer government program business, gifts to government program beneficiaries, gifts to physicians who refer designated health services payable by Medicare, gifts based on referral patterns, meaning the gifts are only given to those who refer business, or bigger gifts are given to those who refer more business, gifts to patients who receive significant services, or gifts that were given shortly after significant services were provided. If that's the case, it looks like you are giving gifts to induce referrals, which means you probably have an anti-kickback issue. So, how do you avoid this? Benjamin Franklin was right. You don't want the government knocking on your door. An ounce of prevention is worth a pound of cure. You need to develop an appropriate gift policy as part of your compliance program. Presumably that policy will address things like the following: the limits on gift giving, like we've talked about earlier in this program. You should require a compliance officer review before giving or accepting a gift of more than nominal value, presumably $10. The gifts received, you might consider making sure that the gifts received belong to the group or the hospital or the facility and not to any individuals. That will minimize the chance that this person's going to act improperly and in order to induce referrals or get the gift. Questions concerning the policy should be directed to the compliance officer. Your people must report suspected violations to the compliance officer so that they can take appropriate action, and make sure that the violations may be subject to appropriate discipline, which in extreme cases could result in termination of privileges or termination of employment. You need to implement a method to track gifts to patients or referral sources if you're going to rely on that $10 per gift or $50 in the aggregate, so that you have this little spreadsheet that tracks the amount that you're giving out to your gift. In addition, if you're giving gifts to physicians who are making referrals for designated health services, you'll want to track to make sure that the aggregate amount of those gifts that you're giving to those physicians are not more than $385 annually. You'll want to train your staff on your policy so that they understand these rules, and then document that training so if the government ever shows up, you can show you did everything that you should have in order to protect yourself. For more guidance, you can go to the government's website and look at the OIG Compliance Program guidance, which will help you establish an appropriate compliance program. If you identify significant non-compliant gifts, you're thinking, oh crap, I wish we hadn't done that. you need to make sure that you understand what the potential consequences are. If you have given a gift or received a gift improperly, it may prohibit you from making referrals to that giver, or for providing items or services in response to a referral that you received from that particular giver. And if you have received payment from government programs for items or services that were provided per an improper referral, you may have an affirmative obligation to report and repay those amounts received per the improper referrals. That could be gifts in violation of the Stark or the Anti-Kickback Statute. Remember, the False Claims Act says if you have received an overpayment or a payment that was made in violation of the law, then you generally have an obligation to report and repay within 60 days, or you could face the increased False Claims Act penalties. The bottom line is consult with your attorney on those issues. For additional resources, the government has a helpful website. You can go to the government's website, take a survey or take a gander through its Compliance 101 series, which talks a lot about these issues and has written and video sources that you can use both to train yourself and to train your staff. Has a whole bunch of stuff there. And with that said, that concludes our presentation for today. We are in the process of developing our presentation schedule for next year. If there's any particular issues that you would like to have us address in our monthly webinar series, shoot me a quick email. If you've got questions about anything that we have talked about today, shoot me a quick email and I can attempt to answer those questions offline. Otherwise, thank you very much for your participation. I believe we've recorded this presentation and it will be available for playing in the future if you want to take a look at it. Otherwise, I hope you guys have a happy holiday season.